Let's go to one of the big stories of the day, the Fair Work Act and the independent review, which today found that Act, according to the review, had not led to a wages blowout, damaged productivity, nor even cut business competitiveness.
Indeed, and as promised, joining us from People and Culture Strategies, the principal of that employment law practice specialist, Joydeep Hor. Joydeep, welcome to you. Thanks for joining us from the Melbourne camera this afternoon. You know, just understand the framework, the parameters of this review. From a legal perspective, importantly, when rubber hits the road, what from your experience has begun to throw itself up as red flag issues, now that we're underway with it?
Yeah, I think the terms of reference of this review are very interesting. There was certainly a requirement for this panel to look closely at the impact on productivity as a result of the Fair Work Act introduction, which was, of course, on the 1st of January 2010, so it's been in place for 2.5 years. It's a very comprehensive review, there's no question about that. There are very few aspects of the review, of the Act rather, that aren't formally addressed in what is a close to 300-page document. Indeed, it's a very considered dissertation on industrial relations and its history in Australia. I think there'll be a lot of people, though, who will be very disappointed with the fact that the review does not appear to grapple with some of the real live issues that I think it needed to grapple with if it was going to be a genuine look at whether the IR framework in Australia is working.
Namely what? What's coming to mind for you?
So I think there's a lot of fringe issues. There's something like 50 recommendations, Brooke, that the panel has made. On my reading, 40 plus of those are of a largely technical nature and would do nothing more, even if accepted in their entirety, than slight tweaking of the legislation. There's a lot of content in the report around enterprise bargaining, industrial action, all of the important topics, but the recommendations don't go to what I would say are those core issues. In fact, the core issues, as I would see it, have to go to the employer-employee relationship. Is this legislative framework allowing employers to employ more people? Does it do what it needs to do, not just from a productivity point of view, but in terms of the enhancement of employer-employee relations? I don't think even from the union side of the fence they would say that this review has delivered much to them. There'd be a lot that they would have wanted by way of clarity around the process of enterprise bargaining, for example, and whether employers can go through the motions of bargaining but not actively bargain. So I don't want to be pejorative, but there's a lot more that this review could have and with respect should have done.
Because Bill Shorten today, and I quote, says this report, people should be in no doubt, this report recommends sweeping changes. You would just kind of flatly disagree with that?
Well, I think it recommends numerous changes. I wouldn't say that those changes, even if accepted in their entirety, would be sweeping. Okay. For example, two of the changes relate to the time periods for the commencement of claims. A suggested increase from 14 days to 21 days to bring unfair dismissal claims, a reduction from 60 days to 21 days to bring claims under the general protection section. That's 2 out of the 50 there. Now, if time limit issues are seen as sweeping, well, I think there'd be some difference of opinion around that.
Joydeep, the Australian Chamber of Commerce and Industry's Chief Executive Peter Anderson releasing their response saying, if anything, legal claims and speculative union activity, employers who've been bearing higher labour costs on the back of that have had their hopes dashed. Just outline what's the kind of paradigm of speculative union activity and legal claims that maybe render this Fair Work Act, I suppose, problematic because it is impinging on productivity.
Yeah, I think there's the particular issue that I expect was being sought to be addressed in that comment was the types of claims that have been made in the context of enterprise bargaining, claims made by unions that relate to terms and conditions that they say should be included in enterprise bargaining agreements in respect of their members, those employed by the particular employer in question. I don't know necessarily whether I'd say that there's going to be a significant increase in that as a result of this particular review being handed down. Indeed, there's a big question mark as to what, if any, of those 50 changes will happen and the timing of that, recognising that there's an election not too far away and no doubt IR will be a pretty hot topic in that contest.
Was the legal community, were you as a practitioner consulted yourself, or were your submissions called for? If so, what did you put forward as part of this review?
We didn't ourselves put forward a submission as a firm. There are certain firms that did. There are certainly any number of organisations and entities that could have. The parameters talk about having consulted with industrial lawyers. One of the things that I know was addressed by a number of parties was the volume of claims being brought under the general protections heading, whereby we have seen some very high income earners use that remedy to bring de facto unfair dismissal claims, which has certainly contributed to the workload of Fair Work Australia and has given rise to a number of quite high-profile cases in the bullying context, in amongst a number of other things. And there's got to be a question mark, which, in my view, was not satisfactorily addressed in this particular review, as to whether that was the intention of those particular laws when they were introduced in the Fair Work Act. And the real question, and I go back to my initial comments, is this Act has got to be about employability, and it's got to be about the employer-employee relationship, and whether the Act serves to enhance that particular relationship, and whether it's easier to employ people. And indeed, in fairness, when an employer reaches the point where it needs to remove someone, whether the Act introduces roadblocks to the detriment of ultimate employability. And so there's a lot of those things that I just don't think have been addressed.
Yeah, there's been plenty of high-profile cases, as you've just said, I guess, helping us to understand how this new system's working, and probably plenty more cases that you see that we wouldn't see. Are there certain cases coming to mind where you look at this Act and say, well, the review today, and so, you know, it does or doesn't shed any light on how things, some of the cases we've already seen could have been dealt with more effectively, or been a smoother process? I'm just wondering practically how you're seeing that this changed anything, or adds any light.
Yeah, absolutely. I think if we take probably the most high-profile example of industrial action in the last 12 to 18 months, or certainly in the life of the Fair Work Act, you would say that the Qantas situation would have to be that particular example. It's by no means the only one. There have been several others. On my reading of the review, it's not suggesting any changes to the regulatory framework that would have allowed that particular matter to have been dealt with considerably differently. In fact, there is some suggested reform proposed in terms of Fair Work Australia's role, but it's certainly not as radical as being able to break through, as a lot of commentators were saying should have happened, certainly at the height of the Qantas dispute, when, of course, you know, the airline was grounded.
Yeah.
Joydeep, just before we leave you, there was one further proposal I wanted to flag, and this is again being considered by Fair Work Australia, and that is a merit-based revision of modern awards to tailor hours and penalty rate structures to, if anything, contemporary trading conditions. Have you got a sense as to where Fair Work Australia is likely to land on that issue to bring us into kicking and screaming, dare I say it, the 21st century?
Yeah, I think Fair Work Australia has a new president, and I think already what we've seen from President Ian Ross is that there's a lot of pressure being put on Fair Work Australia as an institution to be modern, be relevant, and indeed be proper and appropriate in light of some of the scandals and negative publicity that is attached perhaps to some of the exercise of that institution's functions. I think when it comes to that particular issue, Carson, in terms of the modernisation of terms and conditions, I'd be surprised if Fair Work Australia didn't take a quite pragmatic view, and certainly in introducing modern awards at the beginning of 2010, a significant level of reform was introduced as part of that process, and full credit to the tribunal.
Merit-based, one based on merit, though, a merit-based provision, quite clearly?
Yeah, well, look, I mean, the parameters of what Fair Work Australia relies on to make the changes will ultimately be influenced by which particular members are there, but a merit-based one would think is appropriate.
So, if anything, still a work in progress, but you're not altogether saying it's not necessarily bearing fruit. It's a time will tell proposition. Yeah.
As I think numerous aspects of what Fair Work Australia and indeed the government will do post this particular review.
Joydeep Hor, thank you so much. In between meetings, dashing here and there for us. Thank you. People and Culture Strategies. We'll speak soon.
Always a pleasure. Thanks, Brooke. Thanks, Carson.
Let's move on.